welcome to the 267th Legal Empowerment through Empowerment through interactive lecture series. And it has been a wonderful journey. Almost we have become a family, an extended family, and we have been dealing with topics of, diverse topics. Today, just like that, Justice Ramakrishnan sir was saying when we started off in the informal meeting prior to this meeting, that what exactly is the topic? In fact, that itself is the beauty of the topic, I believe, like the gig worker conundrum, regulation of the blue-collar gig economy in India. It's very easy to take persons for a ride. I think this is one new invention. Technology, of course, gives us very many benefits, but it also throws up challenges legally and otherwise. The mismatch of the traditional benefits like healthcare or, for that matter, pension, etc., has somehow been whittled down by saying that you got flexibility, you got freedom, you can do your own boss, zero-hour agreements. It's wonderful. I mean, different terminologies have come up, and today we have a wonderful speaker, Gayathri Poti, who is an advocate practicing both in Kerala and Karnataka. And to introduce the subject, we have Justice A.K. Jayashankaran, Nambiar, Judge of the Kerala High Court, who is part and parcel of this family, but addressed us earlier and also was a regular participant when time did permit him. And we are privileged by the presence of Justice Ramakrishnan sir, Professor B.T. Call, and all of you wonderful participants in this journey of discovery, empowerment, and enlightenment. So today, let us see what exactly is this. Is it a scandal? Is it, in fact, something technology has given us as a boon or a bane? Or when you call somebody a worker, the conventional theories of labor and industrial laws cannot be imported. Then you call him as an associate. Is he really an associate, or is he being associated with something entirely different? Does he have job security? Is there any necessity for judicial or legislative intervention? Or just like we say, when you enter into an agreement with open eyes, it's a free market. You suffer the consequences. Can we be mute part? Spectator? So, is it a win-win situation as they would like us to believe, or is it something of a new colonization or an exploitation as some others would like us to believe? I don't want to believe anything. I would like to hear from the expert. And for the introductory remarks, may I request Justice A.K. Jayashankaran Nambiar, sir, please.
Thank you, Shyam. And first and foremost, congratulations. I was quite surprised that this is actually the 267th session. I remember being an integral part of the first 50 when I was a speaker or something. And at that time, I had, your enthusiasm, I think, made you proclaim that you will go up to 100. But this has gone way beyond that. So congratulations, and I think it's a wonderful thing that you're doing, because if there's something that I've learned over the last 2 years, is that this pandemic, in a particular sense, is God-given. In the sense it did give you a lot of time to actually read and also engage in these fruitful discussions. So if there's something that has actually come out positive from this, apart from your testing of positive, I think it is this enlightenment that comes through the discussions. So once again, congrats, Shyam, for that. Gayatri, I'm happy to be here to be introducing Gayatri to the crowd, or to the world, as I told her yesterday. Gayatri is somebody I've known as a toddler, for those of you who don't know much about her, she comes from a great stock, a great legal pedigree. Her grandfather was the Chief Justice of the Kerala High Court. Her father is a reputed senior advocate in the Kerala High Court in his own right. Gayatri entered the world of law after graduating from Jindal Law School in Sonipat. And I was fortunate to mentor her in the initial years after that, a couple of months after that, when she joined, and she was with me in my chamber as an intern, before then joining Menon & Pai, which is a firm where I was a senior associate, a senior partner, before I was elevated. Gayathri has now moved on to Bangalore, greener pastures, I'm sure, as far as she's concerned. Uh, and she's from what I hear and what I've read about her, she's doing pretty well in a chosen sphere, which is labor law. I think she was more eminently suited to speak on this subject because I know for a fact that she is endowed with a very sharp, incisive, and analytical legal skills. So I'm actually waiting to hear from her on this topic. The topic itself she has chosen quite appropriately, worded as gig worker conundrum. Now, why is it a conundrum? It is in fact a conundrum, and conundrum is basically a very confusing question. And the very concept of gig worker poses a confusing question. Now, why is that? You all realize that a gig. Let's start with the word gig. It was not known in our legal circles till recently. It's basically a word of American origin and refers primarily to part-time jobs, a short job or a short performance by a musician or by an artist. So you would say that go and do your gig. It was basically an informal expression, but changing economic times and economic conditions coupled with continued development of technology has now brought about a radical or a paradigm shift in the concept of employment and work as we know it. Traditionally, the concept of work and employment was you went to a 9 to 5 job. You were under the control of the employer. You spent hours in his premises, and he would control you not only in the sense of having you inside and locked up inside his premises. He would also tell you not only what work had to be done, but he would also tell you how it had to be done. And therefore, you were basically held captive within a premises. If I can use it, if I can be very pessimistic or negative about it. And for this, you were duly compensated, or one wanted to think that he or she was being compensated because his liberty was not there, so he was stuck in a establishment, and for that the employer had to compensate him in some ways. So he received not only a salary, but he also received or wages. He also received allied benefits like medical benefits, and he would be paid even if he was not working on any particular day. Leave pay. He would get other welfare benefits like maternity benefits, etc. Now, contrast that when you look at it from the traditional legal landscape. Contrast that with another category of persons who you had even then, who were called the independent contractors. And these are persons who did not form part of your establishment, was not part of your regular workforce, but you would call these people in for some specified job which required an expertise which was not there normally for a person inside your organization. You would also try and bring him in for a particular project or a particular duration, so that you did not have to spare your workforce for that and end up paying them much more in terms of welfare benefits, etc. So this is not a concept that was unknown in the traditional sphere. It was very much there. But what has now happened because of the changed economic conditions and the technological advancements is that the traditional employers have now seen it more fruitful, more economic for them to shift into this mode of employment. And the same is the case for the worker also. A worker in the tradition, he's now called the consultant or an associate, as the case may be. He now is promised a freedom. He is now promised a degree of flexibility in his working hours. He's also promised a certain autonomy, as Shyam was saying. You're promised a status of being your own boss. Now, whether that is reality or whether that is myth, there are divergent views. There are people who have worked undercover in agencies like Amazon and Uber, and have come out to tell gory tales of the kind of exploitation that they have faced as a consultant or an associate. And if they are to be believed, then you're far from being a boss of your own doing. So where does this actually take us in terms of regulation? And this is my personal view on this is I would think that an attempt at trying to adapt the existing laws to the changed situation is an exercise in futility. And I say this because you're talking about a paradigm shift in the very concept of employment. And the past experience has also shown us in allied fields like taxation, when you have the earlier legislations taking care of the old situation where you traded, in a physical market, and the new platform on which you now do trade and commerce, which is electronic, the old laws are not suited to them, and therefore you need to make a conceptual shift in the manner in which you treat those businesses, and similarly in the manner in which you treat these employments. So I think the way forward, and Gayathri would tell you better, I think the way forward would be a basic process re-engineering and reimagining of a new legal landscape. And a new legal landscape that understands the nature of the work now performed, together with what are the expectations that a worker has. Because today, unlike maybe 10 or 15 years ago, the individual in India, if you were to take India as the playing field where you're making these discussions, the individual's rights are different from what it was about 15 years ago. And we have our Supreme Court to thank for that, because they've read in a number of rights into the constitutional guarantees. And to take a basic example is the right to privacy now, which includes the right to choice, the right to dignity. And these things are not empty rhetoric. I mean, they actually translate into reality when you actually interact with people in society. So I would think, and I would hope, that when in the new environment, a person engages a consultant or an independent contractor or a gig worker, the employer would be forced to, by virtue of the constitutional guarantees that are offered by the state, to recognize the dignity or the inherent worth of the individual he's employing. And the legislations and the regulations that must be put must be basically anti-exploitative in nature and recognize the worth of the individual that he's hiring. And this, in terms of economic benefits, would translate into everything that is necessary for that person to lead a life where he can offer those services to the satisfaction of the employer. So I think that would be the way forward. But as I said earlier, this is my personal view, and I don't want to encroach into what the thought process of Gayathri out here. So with that short introduction, let me hand over the proceedings to Gayathri. And yes, Gayathri, over to you.
Thank you, sir, for those very, very kind words and wonderful introduction on the topic. I'm just going to screen share my PPT. I have a PPT prepared. So
it's enable, you can.
is it visible, the PPT?
You can make it full screen so that. Even otherwise, it's visible.
No, it is visible when you go for each this thing. It will come in the screen.
Okay, because I tried enlarging it, but it's not.
No. What you can do is that on top you will find that slideshow. Just press the slideshow. Slideshow.
Okay.
Yeah, on top. Just press the slideshow. Yeah.
Okay.
Yeah. Then you from the beginning. This end. Yeah. from beginning. Just press that.
I pressed that.
It has to come. It will come.
Okay.
Yes.
So
This is
today,
something I learned in the last 267 sessions, if nothing else.
I can imagine, but I'm still slightly handicapped when it comes to a few of these things. So today's topic is the gig worker conundrum, the regulation of the blue-collar gig economy in India. Jayashankaran sir has already given a very extensive and detailed introduction on the topic. And the reason why I chose this topic is because I don't think a lot of us have realized this, but the gig economy is actually a substantial portion of not just India, but the entire world's workforce. So according to a report by the Boston Consulting Group, the gig economy can actually service up to 90 million jobs in India's non-farm economy alone. And this essentially would translate to over $250 billion in terms of volume of work and contributes to around 1.25% in terms of GDP contribution. So this gig economy, in fact, a lot of people have started saying that this is the fourth phase of the Industrial Revolution. And it's definitely emerging as one of the largest employers not again in India, but across the entire world. So under such a new and dynamic circumstance, I think it's very important that we clarify what rights are available to such a large population of the workforce. Because when you have so many people being employed under the gig economy, you cannot have a situation where there is some ambiguity in terms of workers' rights and whether or not they're entitled to XYZ protection. It has to be absolutely clear and unambiguous, and which is why I've selected today's topic, which is regarding the classification of gig workers. Are they independent contractors? Are they employees? Because that is directly determinative of the rights that are available to these gig workers. So before I start, I just want to talk about who gig workers are, and very small introduction. There is no universal definition of the term because, again, it is quite dynamic and ever changing. But it is an employment model that has a slightly very peculiar work arrangement. So a gig worker is normally a person or a professional who, instead of receiving regular income, he receives wages based on one-time projects or quote unquote gigs. So gig workers are usually those whose services are employed by these digital platforms to service a final customer. And the most common gig worker that all of us interact with on a day-to-day basis, multiple times a day, in fact, are your Uber, Ola drivers, your Zomato, Swiggy, Big Basket delivery agents. Now, the concept of gig per se is not a very new concept, but there is an increased use of technology, which has in fact led to a rapid proliferation of this type of work. So we need to also understand that the marketplace has been digitalized today. So everything, whether you're buying a service or a good, all of this happens through an online medium or through an app. So it is in this context that gig workers become very important because they're essentially employed by these apps to carry out these services of delivery of goods or services themselves. And I also need to just preface my discussion today with one aspect, which is that there are various kinds of gig work. So there is sophisticated gig works where you would hire, say, a management consultant. And that is, of course, a more white-collar type of gig work. But today I will be discussing blue-collar gig workers. So your more labor-oriented gig workers like your Uber, Ola, Zomato, Swiggy, gig workers, and the gig workers were in particular employed by these digital platforms. So first, I'm going to deal with the current classification of these gig workers by these digital platforms who employ them. Now, this question, like I'd already mentioned, is vital because it is on the basis of this classification that we then determine the benefits that are available to these gig workers in terms of the labor enactments. Now, right now, what generally happens is that all gig workers who enter into employment with these digital platforms, they are compulsorily mandated to enter into contracts. And these contracts are, of course, slightly one-sided. They're drafted by these digital platforms. And according to these contracts, these gig workers are categorized as independent contractors and not as an employee or a workman of these platforms. And the question is, why is this the case? Now, if you look at the equation between a gig worker and these platforms, on a surface level, it does appear as though this is not a very typical employer-employee relationship because of the amount of flexibility that's afforded to these delivery agents or these gig workers. It is a very unconventional type of labor arrangement and does not resemble one of your traditional long-standing employer-employee relations. So I'll give you a few instances of the flexibility that a gig worker would have. So a gig worker can decide when he or she wants to work. So he can log into the app whenever he feels like. He can log out of the app. He can decide when he wants to stop working. So he can log out of the app when he wants to. There aren't any fixed working hours. And a gig worker need not accept every ride or request that comes his way. And most importantly, a gig worker can also work for a competitor. So a driver can work for both Uber and Ola at the very same time. So on a superficial level, if you look at it, it looks like these gig workers are independent contractors who do work for themselves. And the companies are just digital platforms that facilitates a sort of an arrangement between this gig worker and the final customer. And this is also precisely what is said by a lot of these companies. So these companies often argue that we are only intermediaries and we are not responsible for the welfare of the gig workers because our role in this entire setup is very limited. And so therefore we aren't their employers per se, they aren't our employees. And therefore we should not be mandated to provide the benefits that are usually available to regular employees under your various labor enactments. Now I'm going to go through a few clauses of the services agreement that has been entered into between Uber in the UK. This is not an Indian agreement, but I'm fairly confident that the terms should be universal across various jurisdictions. So this is the services agreement that has been entered into, a few clauses from the services agreement entered into between Uber and the drivers. So the agreement between the Uber and the driver, essentially, according to this agreement, Uber will agree to provide the electronic service to the driver, which is basically access to the app and the payment related services. And in return, the driver will agree to provide the transportation services to the passengers. Now, the agreement states that the customer acknowledges and agrees that Uber does not provide transportation services, and that where a customer accepts a user's request for transportation services made through the Uber app, the customer is responsible for providing those transportation services. I just need to preface this, customer here is the driver and not the passenger. And the customer is responsible for providing those transportation services. And by doing so, this is very important, creates a legal and direct business relationship between the customer and the user, who is the passenger. And to neither Uber nor any of its affiliates are a party to this legal equation between the customer and the driver. So this is what is being said in clause 2.3. Now looking at clause 4.1 of the service agreement, the customer one, which is again the driver, appoints Uber as the customer's limited payment collection agent solely for the purpose of accepting the fare on behalf of the customer via the payment processing functionality facilitated by the Uber services, and two, agrees that the payment made by user to Uber shall be considered the same as the payment made directly by the user to the customer. So I don't know if anyone, I mean, if you can see through these clauses, but there is a repeated this repeated instance where Uber is trying to make it appear as though the ultimate contract or the real contract is between the customer or the passenger and the driver, and that Uber is only an intermediary. They're only providing the electronic services, and whatever payment is being made to Uber from the passenger has to be deemed as payment made directly to the driver. Now, clause 4.2 gives Uber the right to change the fare calculation at any time in its discretion based upon local market factors. And clause 4.3 provides that Uber and its affiliates reserve the right to adjust the fare for a particular instance of transportation services or to cancel the fare. So these clauses will be more, the reason why I'm citing these clauses, it will become a little more relevant at a later stage when I talk about the control that is being exercised by a company such as Uber. And in addition to the service agreement, the Uber has also formulated written terms and conditions, which are essentially called the rider terms, which passengers are required to accept before they can use the app. So even I'm going to go through the terms of these rider terms, but even when you look at these terms, it again reinforces the fact that Uber has very carefully drafted these contracts to limit their role or liability as an employer. So clause 2 of the rider term, I'm just going to read it out. Uber accepts bookings acting as a disclosed agent for the transportation provider, that is a driver, as principal. Such acceptance by Uber as agent for the transportation provider gives rise to a contract for the provision to you of transportation services between you, that is a passenger, and the transportation provider. For the avoidance of doubt, Uber UK does not itself provide transportation services and is not a transportation provider. Uber UK acts as an intermediary between you, that is the passenger, and the transportation provider, that is the driver. You acknowledge and agree that the provision to you of transportation services by the transportation provider is pursuant to the transportation contract, and that Uber UK accepts your booking as agent for the transportation provider, but this is very important, is not party to that contract. So again, there is a constant reinforcement through various clauses, both in the services agreement and the rider terms, which sort of reinforce the fact that Uber has a very, very limited role. Uber is a mere intermediary. All that they do is provide the electronic service, but the ultimate contract is between the customer or the passenger and the driver. Now, if you carefully, like I mentioned, analyze these clauses, you'll notice that these contracts are drafted in a way that it sort of confines Uber's role to that of a very simple intermediary who offers app-based services in return for the transportation services that are being offered by the drivers. And the contract essentially seeks to create a notion that limits the responsibility of these digital platforms to give a perception that the final contract is between the driver and the passenger. And therefore, if you look at this contract, and if you look at the terms of this contract, it does seem more like a contract for service, that is an independent contractorship, versus a contract of service, which is your typical employer-employee relationship. Now, what is the reason for such classification? Now, one thing I also need to mention is this contract with Uber was more easily accessible, but these contracts are ubiquitous amongst various digital platforms. This is not just Uber, but if you look at any digital platform and their hiring of gig workers, this is more or less how all the contracts are drafted. So the contract itself makes it unambiguous through its wordings that the platforms are merely intermediaries. They're solely responsible for providing technological services and nothing more. And in return, the driver will provide the core service of transportation. So it's ultimately the driver who is carrying out a majority of the service under the contract. Now, as I mentioned, these contracts are very strategically drafted because it projects the gig workers as an independent contractor and not as regular employees of these companies. And the reason, again, I've already mentioned, the reason why this is being worded in such a way, and which is the argument that is put forth by a lot of these digital app-based companies, is that the nature of employment that is offered to these gig workers, it has a tremendous amount of flexibility, and it does not resemble a traditional employer-employee setup that is usually found amongst other employees that are employed within the digital platforms itself. And at the cost, I'm going to be a little repetitive, but just to sort of drive in the flexibility aspect, like I mentioned, they can choose when to work, they can choose when not to work. There are no fixed working hours. They can work for various other companies, including the platform's own rival. They are not compelled to accept a ride, of course, though once they accept, there are penalties for unnecessarily canceling rides. So the question of why do these digital platforms go out of their way to classify gig workers as independent contractors and not as employees might, on the first blush, it does seem fairly self-explanatory. Like I said, I've gone through the flexibilities that are afforded to these workers. And if you go through the terms of the contract, it seems like a fairly clear-cut case as to why they are being termed or acknowledged as independent contractors and not as your traditional employees or workmen. But there's something that is slightly more what one would say insidious, which is that the classification is not simply because the nature of employment is such, but to a large extent, it is also driven by the fact that the classification will enable these digital platforms to avoid labor regulations, which would be attracted if these gig workers were to be classified as employees as opposed to independent contractors. So I'm just going to talk about the implication of being classified as an independent contractor in terms of the labor laws. So now, as a consequence of the contracts that are being entered into between the gig workers and these digital platforms, the gig workers are essentially bereft of social security that is available under your various labor enactments. I'm going to, this is actually a list of the existing labor statutes, which usually offer quite a bit of protection to the labor force. And because of the categorization that is currently being given to these gig workers, they're not entitled to any of the benefits that arise out of these enactments. So, for example, the Workers' Compensation Act, which is an act to ensure payment of compensation by the employer to the workman if he meets with an accident during the course of employment. So now, if a gig worker, in fact, this is a very sad and unfortunate situation, and this has happened a couple of times, but if a gig worker is going to deliver an order and he meets with an accident, he is not entitled to compensation under this enactment. The compensation is purely dependent on the benevolence of the digital platform or some token compensation that they might offer to the gig worker or his family. But there is no mandate as per this act because, again, he is not being classified as a workman. Similarly, Payment of Wages Act, which provides for timely payment of wages and prevents unauthorized deduction from wages. I don't know if this is something I've personally encountered many times, but a lot of the times, especially with Ola, but a lot of them will not take or accept the ride if you're paying them through Google Pay or through the platform, because a lot of them complain that the payments are not made adequately on time. There's a 1 week lag between when you pay the app and when they receive that amount. So all of this would be remedied by something like this enactment. But again, because they don't fall under the ambit of a workman, they're not entitled to any of these benefits. Minimum Wages Act, since they're not employees or workmen, there is no scope for the government to include these workers within the list of scheduled employment and guarantee them with minimum wages. There is the Maternity Benefit Act, Payment of Gratuity Act, Employees Provident Fund Act, State Insurance Act, and very importantly, the Unorganized Workers Social Security Act. So since these gig workers are not considered to be unorganized workers today because of their ambiguous employment status, they don't fall under the ambit of this act, which basically means that they're not eligible to have any schemes created or framed by the government under this enactment. So now I'm going to move on to the validity of the current categorization of gig workers as independent contractors. So currently, looking at all of the evidence that I've referred to up until now, it does point or indicate or signal to the fact that gig workers are independent contractors. And there is another side which I'll discuss after this. But before that, we need to, before we go into the validity of this classification rather, we need to address the issue of how does one go about establishing whether a working relationship is in the nature of a traditional employment, that is a contract of service, or whether it is an independent contractorship, which is a contract for service. So one of the first tests that was developed by the Supreme Court in the 1950s was a test of control and supervision. So the Supreme Court borrowed from British jurisprudence on this matter, and they came up with this test that says that according to the parameters of this test of control and supervision, if the employer has the power to not only direct what work the employee has to do, but the manner in which it has to be done, then it resembles a contract of service. And vice versa, if there is no hold on the manner in which this is to be done, then it is more in the nature of a contract for service or an independent contractorship. But subsequently, the British jurisprudence also gradually changed, and they realized that this test alone is not sufficient. And the Supreme Court also went along the same lines, and they adopted the view that the traditional test of control and supervision has actually become insufficient to accurately or positively determine whether a certain working relationship is in the nature of a contract of service versus a contract for service. Because this test was essentially developed in the 19th century, when your main forms of employment was domestic, agricultural, and manual. But now, subsequent to that, there was quite a bit of modernization in terms of the nature of employment. And there was the rise of skilled employment. So you had doctors, pilots, architects. And when you have these kinds of new forms of employment, not new for us, but new back then this test of control and supervision would not work, because in a case where there is skilled employment, the manner in which the work has to be done is also to a large part determined by the worker himself and not by the employer. So there the court began to say that in this changed world or in this changed context, the test of control and supervision can no longer be relied upon as a sole test. But the test of control and supervision still did, back then and even today, does hold a strong ground in terms of determination of nature of employment. But of course, it is not conclusive or solely determinative of the classification. So then after a while, a substitute test was developed, which was called the integration and organization test, which again was developed by British jurisprudence and then adopted by us. And as per this integration or organization test, the working relationship is in the nature of a contract of service if the worker is employed as a part of the business, and if his work is an integral part of the business. Whereas the working relationship is in the nature of an independent contractorship or a contract for service if the work is being done for the business, yes, but it is not integrated into the business, and it's only an accessory, it's only adjunct to the business. But again, the Supreme Court has repeatedly mentioned that there is no single test that is accurate or determinative. And throughout, in many of their judgments, the Supreme Court has reiterated the fact that in order to determine whether a working relationship is in the nature of a contract of service or a contract for service, it has to be a case-by-case analysis has to be done. And there is no single test that you can apply in order to come to the answer. And there are a few other indicators which through various case law, the Supreme Court has held there are a few that might indicate one way or the other. I'm just going to go through it very briefly, the ones that are relevant for our purposes. One is if, so these are the characteristics of a contract of service. A worker would be an employee if he has agreed to work personally. And if he's promised to work personally, it is irrelevant if he actually takes assistance from other persons who work under him. Then another indicator is the employee has, this is very important for our context again, the employer has the power to reject the end product of the worker if it does not conform to the instruction of the employer. And the worker can be directed to rework on the assignment, because this power would in fact indicate that there is an element of control and supervision that takes place. Again, the employer has the power to refuse work to a worker if, say, the worker has not performed his work in a satisfactory manner, because again, this would signal to the fact that there is an element of control and supervision. Then if the employer has the power to suspend, dismiss, or terminate the engagement of the worker. And in other words, if he has a liberty to remove the worker from the employment. And if the employer similarly has the right to select the worker, if he has the direct obligation to provide payment or remuneration of some form to the worker. And the degree of control and supervision by the employer on the worker, again, this is a broad comment, but it's different in different types of businesses, and especially with something like your gig economy, which is very new, very different from anything we have seen before. You can't strictly apply one sort of test versus another. You need to factor in the various different kinds of indices, and then on the basis of that determine the level of control or whether there is actually a relationship of employer-employee. And what one would take away from these tests is that the degree of autonomy is the most important. In that, if the employee has more autonomy, then it would hint to the fact that it's a contract for service or an independent contractorship. Whereas if there's less autonomy and more control, it is more in the nature of a contract of service. And there is no magic formula or test which can be propounded to indicate which factors of the relationship should be treated as the determining ones. You have to take a holistic view and look at all the different factors and apply various tests to all the factors to see which is the more accurate classification. Now, this is very important. I'm going to so up until now, I have discussed the terms of flexibility that are being offered to gig workers. Now I'm going to dissect the terms and conditions in the background of the aforementioned tests. So the terms that I discussed up until now, it doesn't paint the entire picture of the employment conditions under which these workers or these drivers operate. I'm going to cite certain employment conditions, which these are Uber conditions, by the way, the conditions imposed by Uber on the Uber drivers, which actually indicate that the digital platform, or in this instance, Uber, has a tight rein of control over its employees. So the most important is the remuneration. Now, an Uber driver has no say in the remuneration. He does not decide how much money is to be charged or paid. And it is the app that solely has a sole discretion to determine the amount of charge payable by the passenger. And the driver, once this amount has been determined, the driver cannot go above this amount. Now, even assuming the driver for some reason wants to offer a discount, the commission that is payable to Uber is not on the amount that is actually charged or the discounted amount. The commission payable to Uber is still on the amount that has been originally calculated by the app. In fact, Uber's control over the remuneration also extends the right to decide in its sole discretion whether to make a full or partial refund to a passenger in response to a complaint by the passenger about the service provided by the driver. So again, if there is a complaint, Uber decides whether they should be refunding the amount. And of course, in case of a refund, that also means the driver is not going to be credited with that much portion of the fare. Then the second instance where I would say there is control being exercised is simply on the contractual terms. The contractual terms are entirely dictated by these digital platforms. There is no scope for negotiation. There is no scope for bargaining. So if, say, an individual feels unhappy or a little uncomfortable with some of the terms, he cannot go to Uber or these big companies and ask for these terms to be altered in his favor, because these are standardized contracts that are entered into in masses. So there is no scope for one contract being, pulled out and altered to the benefit or to the comfort of some individual gig worker. Another form of control is monitoring the driver's rate of acceptance or cancellation of trips rather. So the driver has no compulsion to accept a trip. That is a flexibility afforded to him. But once he accepts a trip, he's not permitted or he's discouraged from canceling trips. So if a driver, I believe, cancels more than 3 trips in a row, he is penalized. He is logged out of the app for 10 minutes as a way of penalty, which means that he's not able to make any money or accept any rides in these 10 minutes. And if he continues with this behavior of canceling rides, then he is permanently at some stage disqualified from the app altogether. His services with Uber are terminated in entirety. Then Uber also has we all say, oh, these Uber drivers use their own cars, and then so there is that element of flexibility. But even in terms of the vehicles that are being used by a company, by these drivers, they have to be vetted by Uber. So Uber has some standard prescribed models and types of vehicles and colors. And in order to become a driver and to be engaged by Uber, your vehicle needs to conform with all of these specifications. You can't have a completely different or outdated model and then be expected to be hired by Uber. Another aspect is the technology, which is integral to the service, because the technology aspect is wholly controlled by Uber. And this is again used as a means to exercise control over the drivers. So the route taken, the driver has to ideally follow the route that is prescribed by Uber, assuming he takes a different route and assuming, unfortunately, that the passenger complains about the route. Again, it will result in him being penalized because he doesn't have a say even over something as simple as a route to be adopted while traveling from one destination to another. Now, this is also a very important aspect, which is the use of the rating system, which is an internal tool whereby passengers are asked to rate a driver after each trip. And if a driver does not maintain an average, and I believe this is a 4.4, if a driver's rating goes below 4.4, he is issued with repeated warnings. And if beyond a certain period, he's not able to bring up his score, he is then permanently removed from the app. So again, it results in his termination. And what is most interesting is that normally a rating system is used to incentivize drivers to perform better because it would result in more people choosing this driver. Say you have a higher rating in the market, more people will be willing to go to you as opposed to your competitor. But in the scenario of an Uber, your ratings are not for the purposes of a passenger to choose which driver they want to go, or that they say, I'm willing to pay more for this driver because he or she has a higher rating. The rating system is purely an internal tool that is used to manage the performance of the driver, and that is used for the discretion of say terminating the driver from his services. So the rating system also is very, very indicative of the control or the tight rein that these employers or these digital platforms have over the gig workers. Even in terms of the communication or the relationship between a passenger and the Uber driver. Now, Uber does everything in its power to discourage any sort of relationship from the building of any sort of relationship between the passenger and the Uber driver. So they're not given each other's real numbers. The numbers are proxy numbers. And once the request is accepted, the communication is restricted to information relating to the ride alone. And Uber drivers are prohibited from contacting the customers after the ride ends, unless, of course, there's some exigency where, say, there's a lost item or something along those lines. So when you look at all these factors, you can say that the transportation service that is performed by these drivers and offered to the passengers through this Uber app is actually very tightly defined and controlled by Uber. It's not as rosy a picture as is painted by these digital platforms. And if you go beyond what the contract states, because the contract, of course, makes it seem as though Uber has a very small role to play. If you go beyond the contract and beyond the narrative that is generally drawn by all these companies, you will notice that even though these platforms pretend not to keep a tight rein over the gig workers, there is a lot of micromanagement and restraint that is placed on these workers. And the above indices that I just mentioned, they strongly suggest, though of course not conclusively, that there is a strong case in support of gig workers in terms of their employment categorization. But the contracts, again, that are spelled out by these digital platforms that I've already mentioned are very carefully worded. They expunge any potential employment liability. And for a considerable period, in fact, I mean, because we all know that these platforms have been operating for at least 5 to 7+ years. And so for a considerable period, they have in fact safeguarded the interests of the digital platforms, because they've sort of protected these companies from having to bear any employment liabilities. But it's for the past 2 to 3 years, there has been a shift in the perception in the public, amongst the court, and amongst the workforce itself. So the lot of courts in countries such as Spain, UK, Australia, Canada, I believe, and in a lot of US states such as California, they've begun unmasking the veil, and they've held that platform workers, so these gig workers, are employees for the purposes of employment benefits that is offered under that are offered under all these legislations. And these in the courts have gone to hold that the contracts alone, they're not determinative of the real nature of relationship between the parties. So in fact, we in India have followed suit. There is currently a writ petition pending before the Supreme Court. I believe it was filed in September of last year, where there is an Indian Federation of App-based Transport Workers, which again encompasses Uber, Ola, Swiggy, Zomato, and all your various other digital platforms. They have sought for the rights contained under the social security legislations. And according to them, they fall under the ambit of unorganized workers as defined in the Unorganized Workers Social Security Act. So this case is essentially Indian Federation of App-based Transport Workers versus Union of India. I believe the last stage notice has been issued in this matter. And here what has been argued is that the gig workers, so what is being agitated before the court is that the gig workers and these platform workers, they are in fact covered by the definition of workmen within the meaning of all social security legislations, because they do have an employment relationship with the aggregators, and aggregators here are the digital platforms. Now, the petitioners, in fact, in this case, have sought for a declaration that the gig workers and app-based workers are to be recognized as unorganized workers or wage workers within the meaning of Section 2M and 2N of the Unorganized Workers Social Welfare Security Act 2008. And in terms of their arguments that are being propounded, they say that the failure of the state to register them as unorganized workers or to provide them with any sort of social security under the enactments is a violation of their right to Article 21. And of course, because similarly situated people are getting benefits that they are not, also a violation of Article 14. And the petitioners have also sought for a formulation of schemes which would include health insurance, maternity benefits, pension, old age assistance, disability allowance, and vaccine-related schemes at the aggregator's cost. That is the cost of the cost to be borne by the digital platforms. And it has also been averred that the respondent companies who own these apps, they actually, like I already mentioned, they've pulled out a lot of these instances where there is a strong fist of being exercised by these digital platforms, and they've said that the apps exercise complete supervision and control over the manner and the method of work with those who are allowed to register on the apps. And it's been said that just because these employers call themselves aggregators or partners and enter into these partnership agreements or these service agreements, it doesn't take away the fact that there is a dual relationship of employer and employee, or a master and servant, or this clear subordination taking place, and which would sort of enable the gig workers to be classified as workers. And they say that these contracts, in fact, are just a device to disguise the real nature of the relationship between the aggregator, the digital platform, and the gig worker. And essentially, what in like the crux of what they're arguing is that these digital platforms have engaged in a planned subversion of the laws by tinkering with the contracts, and that these contracts are merely a subterfuge to conceal the true nature of relations between the parties, which is that of an employer and an employee. And they've also placed heavy reliance on the decision of the UK Supreme Court, in which gig workers have been recognized as employees and thereby made eligible to the various benefits available under the labor enactment. So now I'm just going to briefly refer to the UK Supreme Court decision and the manner in which they concluded that gig workers are in fact employees. So this is a decision, I believe, that was passed around approximately a year back. And the issue was whether the employment tribunal was correct in holding that drivers who work for Uber under the various contracts, whether they and qualify, whether the tribunal was correct in holding that they do qualify for minimum wage and paid leave, paid annual leave. And Uber, according to Uber, these drivers did not have these rights, again, because of the classification that was adopted by way of the contract. They said, again, they're independent contractors. They essentially work for themselves. The final relation is between the customer or the passenger and the driver, and Uber has a very limited role. Therefore, we are not employers, and therefore the Uber drivers are not entitled to the labor enactment benefits. Now, the rights that were claimed by the petitioners, so the claimants in these proceedings, were rights under national minimum wage and right to annual paid leave under the working time regulations. Now, according to Uber, in order to answer this question, you have to start with the written contract between Uber and the driver. And Uber would, of course, rely on the terms of these written contracts, because when you look at the terms, it essentially would mean that a request, whenever there is a request to book a vehicle through an Uber app, and whenever the acceptance of the request takes place, a contract is created between the passenger and the driver, and Uber is not a party to that contract. And the driver is solely responsible for providing transportation services to the passenger. And Uber also extracted several clauses that I've already mentioned, which says that Uber will only provide technology services, core transportation service, the responsibility of which lies with the driver. Now, the court, in order to decide this issue, they relied on a 2011 case of the UK Supreme Court itself, which is a case called Autoclens versus Belcher. Now, in this case, the claimants worked as valeters. They would perform car cleaning services, which Autoclens had contracted to third parties. And in order to obtain work, so in order for these valeters to be employed by Autoclens, they would have to enter into contracts with Autoclens, which would say that, and they were expected to sign these written contracts, which stated that the valeters were not employees, but were merely subcontractors of Autoclens. And essentially, very similar to what is happening with Uber, Uber too is not maybe directly wording it as such, but the implication or the conclusion that you can arrive at from the contracts entered into between Uber and the gig workers is that gig workers are not employees and they're merely independent contractors. Now, in this autoclins case, the validators came to court saying that they were, despite the contract, they still ought to be classified as workers for, again, the benefits arising out of the Minimum Wage Act and Working Time Regulation Act. And the court went through a lot of observations on how to reconcile the contract with the statute and how much reliance is to be placed on a contract of such nature. So the court or tribunal, according to them, what had to be considered was what was actually agreed upon between the parties. And either this would be written or spelled out in the written contract. And if it is alleged that the terms of the contract are not accurate or they don't represent the truth of the matter, then what needs to be looked at is the actual agreement or the conduct between the parties when the contract was concluded. So the court said what we need to adopt a purposive approach in this case, because this is a very important aspect. The problem here is there is a very skewed equation between the worker and the employer. There is a question of relative bargaining power. Now, the workers in most cases don't have negotiating powers. And so when you look at this aspect, you need to realize the fact that the relative bargaining power of the parties have to be taken into account to decide whether the terms of the written agreement in truth represent what was agreed. And the true agreement, it has to be discerned from the entire matter as a whole, or from like a more holistic approach. And the written agreement is only a part of it. You can't purely or solely look at the written agreement. You can look at it from a particular angle, but you also have to consider the various other factors and the conduct that is being employed between these two parties. And the court said that what is being asserted by the claimants, they are not asserting contractual rights. They are asserting rights that have been created by the employment legislations. So therefore, what the court does not have to look at the contractual aspects. So they need not look at whether autoclins had agreed to pay the workers with minimum wage or give them annual paid leave. What they need to look at is not the contract, but whether, as per the statutes, whether these claimants or these gig workers, or sorry, in this aspect, these validators could be classified as workers for the purposes of those enactments. So they said this is not a question of contractual interpretation. This is more a question of statutory interpretation and whether these people fall under the statutes irrespective of what the contract states. Now, the reason why the court went or adopted this approach in the autoclins case is because they said it's inconsistent with the purpose of the legislation to treat, if you treat this written contract as a starting point, it sort of defeats the mischief that is being sought to be cured by these welfare enactments. Because most employers, and this is something all of us know, they have a much higher negotiating power. They are in a position to dictate or sort of dictate the contract or make it in such a way that the individual has very little in terms of the ability, or the workers have a very limited ability to influence the terms of the contract. And the efficacy of the protection would be seriously, the efficacy of the protection under these labor enactments, they will be undermined to a very large degree if an employer is allowed to characterize the nature of the relationship merely by a written contract. Because again, these workers don't have much influence over how these contracts are drafted. And this point, in fact, in the court in the Uber case, they said, just look at the service agreement entered into between Uber and the drivers. They're being drafted by big big councils, big firms that are employed by Uber, and they're presented to the driver as containing terms which the driver has to necessarily accept in order to be hired as a gig worker for Uber. And many of these drivers, very, very unlikely that they actually read the terms or understand the legal implications arising. And even assuming they do understand the legal implications, they are not going to be able to get any of their grievances addressed by Uber in terms of the agreement. And therefore, the court analyzed a number of findings. So all these, the instances I gave you where Uber seems to have quite a bit of control, unlike what they claim. So the court analyzed all these instances and looked at the findings regarding the standards of performance which these drivers are expected to meet, and the actions that are taken in case a driver fails to meet these standards of performance. And the court observed that there is very clearly an inconsistency between the terms of the written agreement and how the relationship between Uber and the drivers operate in reality. And therefore, there is a substantial, strong basis to depart from the written agreement. And once you depart from the written agreement, it is very clear that Uber and the drivers clearly share an employer-employee, master-servant, subordinate relationship. And under such circumstances, the UK Supreme Court did go on to uphold the decision of the Employment Appellate Tribunal. And I think even in the Indian context, a lot of these findings would be very clearly applicable. Currently, the matter is before the Supreme Court, and it hasn't reached a point where anything substantial, whether it's at a point where there are any substantial findings on the matter. But something that we need to also know is that the government has recognized the need to frame regulations to protect gig workers. So if you look at the Code on Social Security 2020, it installs a lot of rights in favor of the gig worker. And in fact, because I agree with Jayashankaran sir when he said that the current labor, even if you look at the Unorganized Workers Act, it does not really pin any liability on the aggregators or the digital platform. So we need a different sort of a approach where this nuanced employment setup is understood better, and the legislation is able to better sort of put onus on these bigger companies to bear at least some of the costs of social welfare over these workers. And this code of, I'm not going to actually go into the Code on Social Security. I'll be ending here because the Code on Social Security does have a lot of definitions of gig workers, platform workers, a lot of overlapping definitions. But the problem is, A, it hasn't been notified as of yet, and B, a lot of it is dependent on the schemes that have to be subsequently framed once the code is notified. So only once we have a scheme in hand can we see if it's adequate to protect the rights of the workers or not. And so with that, I will be ending today's talk.
So thank you very much, Gayathri, for that wonderful exposition on that particular and interesting subject. Before we go to Jayashankaran Nambiar, sir, may I request our academician friend from all the way from Delhi, Professor Dr. B.T. Kaul, for his comments.
Well, thank you very much, Mr. Shyam. In fact, you sent a message in the morning that you're going to have this program today. So since I have a lot of interest in this area, I thought I should also learn something which I have not learned so far. I think it has been very wonderfully introduced. The subject has been very well introduced. And also the presentation of the subject has been very well researched. I think, yes, difficulties are there in seeing as to whether these people classify to be workmen or not. And she has rightly said that due control and supervision test, which Indian Supreme Court accepted in Dringadara Chemical Works and subsequently in BD workers cases and all other cases, was a test which was evolved in an agriculture economy. But when we had industrial revolutions and then industries started coming up and they found that this was an inadequate test, So they developed some further tests like organization, integration and organization tests, like we have in very famous case of Supreme Court, Hussain Bai's case, where this was a case relating to the rope industry. You know, they were manufacturing, and employer's case was that they were independent contractors. But Justice Krishna Iyer would be the last person to accept that they were independent contractors. So he brought in, he said, due control and supervision is not the only test. You have also to see it from the point of view of what is the main work that is being carried on in the organization. If this is the integral part of the business of the organization, they are workers of the employer. In fact, it's a very beautiful journey, because Supreme Court has later on also brought in another test, which I think she referred to in passing, is the test of lifting of the veil. They brought in the, and that's a very important test. And I think she referred to many, and that's what is talked about in the UK Supreme Court judgment also, though not directly, but I think it is a reference to that aspect. Don't go by only the silken phraseology in which the words and the contracts are, written. You have to go behind them and see what is the true import of the terms and conditions of the employment, and see what is the methodology adopted by the management and the workers. I think we had also another case which I thought should be talked about is Silver Jubilee Tailoring House case, where the Supreme Court brought in the concept of this flexibility. People would come at leisure hours, come to the factory of the employer, and then they would stitch the clothes according to the standards prescribed. And they brought in all the tests, integral part of the business test. They brought in the test of due control and supervision. And what she said, I think a very important aspect was that with the new problems coming in, of course, legislative role is very important. Law has to evolve. New laws have to come in. And I'm sure when we are talking about the new codes, we are having subsume all the legislations in the 4 codes. But I'm sure these codes are this is the right time, not only to deal with the problems of gig workers, but also to deal with the problems of other workers, like what the technology has brought in, the changes. Those aspects need to be taken in. But till then, we cannot stand and wait and see how these people are exploited and do not come to their rescue. I think we need to have a change in the perception of the courts. I think that was that era when we had judges like Krishna Iyer, Justice Chinnappa Reddy, Justice D.A. Desai, Justice Bhagwati. I do not know whether we have any of them today, but I think still I have some hope from some of them, like Justice Chandrachud, Justice Bhatt, Justice Khanna. I think we need to see these problems. And I think, one important thing that I would say, these people want themselves to be treated as these Uber and other people, like in the Information Technology Act, you have the ISPs. But I think you can't compare these people with ISPs, because they are the people who are dictating the terms. They are the people who are framing the terms and conditions of employment. They are the person who are making the choices. They are the person who are, having complete control, as I think she very wonderfully brought in those important conditions where she tried to demonstrate the ultimate due control and supervision lies with these big platforms, IT platforms. And I think it's time we must see that all kinds of workers, whether they are informal or formal, and what are formal and what are informal, they need to be given protection. They need to be given social security. They need to be, given welfare measures, as is the mandate of the Constitution of India. We cannot forget their rights. We cannot, ignore their aspirations and needs. And till then, I think the rule she talked about, she was referring to mischief rule of construction of statute. She was talking to hidden's rule of construction statute. She was talking about the purposive construction of statutes. I think judiciary has to evolve, and it has to come up to the expectations of the people, and especially these people who I think are in an exploitative situation. So therefore, till the parliament steps in, or the state legislatures step in, which I don't think it's very easy, such a situation to come up, because we still are governed on industrial relations or in many aspects by the legislations which are pre-independence legislation, like you take up Trade Unions Act, Industrial Disputes Act, Industrial Employment Standing Orders Act, Factories Act, 1948. These are all pre-constitutional statutes. So therefore, we need a good judiciary, we need a good outlook for these, and we would like to have more and more disputes coming up before the industrial tribunals and courts on the maybe in the form of the public interest litigations also, to see that we are able to face and give solutions to the challenges that IT has posed to the workers and a vast majority of the people who are working in these organizations. Thank you very much.
Thank you. Thank you, Professor Dr. B.T. Kalsa. I mean, it's indeed wonderful to have you back. We would like to have you more often on this platform. We hope the temperature in Delhi will not in any way dissuade you from being with this warm pack. So, I mean, as we were discussing, the contract of adhesion or camouflaging the Henry VIII rule or the hire and fire rule by having some sort of contracts which looks very rosy on the outside, but have all the hidden traps. Before I go to Justice Ramashan, sir, may I just have the comments of Justice Jayashankaran Nambiar, sir?
Thank you, Shyam. I'm aware that the matter is now in season of the Supreme Court, and so I don't want to, make any comments on the points which Gayathri mentioned are taken before the court. I was just wondering, and this is just a thought, or something that I want to flag, maybe of interest to academicians and lawyers alike. You see, when you're talking of a change in the concept of employment, as it were, and this was something that I mentioned at the outset, I think an approach that tries to adapt the existing legislation to the new scenario is an exercise in futility. What I would rather wish to see is how you're going to deal with the new situation independent of the welfare legislations that we're used to in the past, right? And when you look at that, the one feature that you have to bear in mind is that there is a paradigm shift in the profile of the workman, as it were, from what was existent prior to maybe 10 years prior to 10 years ago. Today's workman, I mean, take the classic case of the Uber driver, right? He's not, majority of them are not the kind of persons who you saw as factory workers in the erstwhile era. You are talking about graduates, you're talking about postgraduates, you're talking about people who left their employment with companies and things, and who are now eking out a means of sustenance by driving a cab, for example. And I'm sure you must have encountered many of those Uber drivers, when you step into those cabs. When you look at the profile of the person who you're dealing with, and he's a sensible person. He's not a man from the village. He's not from the rural areas. Educated also in his own right. Now, when you talk about such persons entering into contracts, you have to assume also that he enters into the contract with open eyes, and it is something that he has agreed to. The level of control or level of the conditions and terms and conditions that Uber imposes are something that he accepts, knowing fully well what they mean. So it's not a kind of exploitation, as it were. There's no undue influence, as we learned in our contract laws. There is a kind of entering into an arrangement or a relationship with open eyes, and being fully aware of the consequences of that. Now, when you look at it that way, maybe looking at welfare benefits which were traditionally available for those who were oppressed and those who didn't have a voice may not be the ideal route to take in order to protect their interests. I mean, I'm not saying that these people don't have interest, because I mean, they may have entered into the contract with open eyes due to compelling circumstances, and that doesn't mean that they don't get looked after. But a possible solution could be, and this is just a possibility, that you bring in the concept of insurance, because what would you do? Suppose you were engaged in a job which was inherently hazardous, and you were not working for anybody. You were undertaking something that was hazardous. Take your own car, for example, and you're driving your car. I mean, you take a comprehensive insurance, apart from the third-party insurance that you insure the victim against of an accident. You also cover yourself and your life through an insurance. Now, if you are undertaking a job which is fraught with dangers, you could insure yourself with that. Now, the question therefore then comes, who pays this insurance amount? Because this is an additional cost for me. That could be regulated through the state. And this could be made a condition by the state for granting permission to the business operator to operate in India. Right? So if you bring in the concept of regulation of the operator, Uber, for instance, in this case, you bring in the concept of regulation of Uber, and you say that Uber has to satisfy the minimum wages or minimum remuneration payable to drivers, which minimum wage is fixed based on all these inputs that go into the price fixation, including the amount of insurance that has to be taken for a person engaged in this kind of activity. Generalize it, and you average it or amortize it, and then you say that this is the minimum wage, like what we're doing presently while fixing minimum wages for various sectors. So you identify the sector, you have the regulation in place, and that can be enforced as a condition for the permission granted to the person to run his business here. If you do it that way, probably you're getting all the same benefits, except you're not getting it directly from because of an obligation imposed on the employer, and you still retain the flexibility, the independence, and the autonomy that you're talking about, which is what actually characterizes this particular area, right? I mean, just a thought. I mean, maybe it's a wild and idea, but I think at the end of the day, we need to balance these interests, because you can't at this stage ignore the profile of the modern workman, and he has an interest in enjoying his freedom, flexibility, and also his autonomy. So to go back to the old ways and trying to impose employers' welfare would be demeaning, in a sense, to the employee, who does not want to be seen as an employee. He wants to be seen as independent. So the balancing of those conflicting ideas can probably come out of this regulation of the business, as it were, right? Shyam, may I also be get your permission to leave, because I have another appointment at 7, and I think it's already 7. Thank you, and I'm sorry. Sorry to all the rest of you who are on the platform. I'm sorry that I have to leave so suddenly. And Gayathri, once again, congratulations. Very good.
Thanks a lot. It means a lot.
Thank you very much. Just like Justice Jayashankaran Nambiar sir said, we come up from a state wherein collective bargaining became collective hooliganism, and the way in which the industry or the state of industry in the state is there to for everybody to know. I mean, it's a standing example. So unequal bargaining power, can it be read into this concept? And also, should it not also enjoy the benefit of infancy protection? Let us say, because this is a new concept that is coming, and otherwise you would not have been engaged, or you would not have such a means of income without all the what you call parameters of a working time, 4 to 5, morning 8 to 5 job, etc., or being has to punch in, punch out, and things like that. You get all the freedom. So when you have freedom, something has to also to be taken care of, I believe. Let us get the comments of Justice Ramesh sir.
Thank you very much, Shyam, because I'm a nuance in this area. And being a new era of providing employment, I can say. See, if you say that you are an owner of the business. By virtue of the contract, all we have said is we are bound by the contract. But here is a case where a type of employment is created and the Uber driver or the Uber vehicle owner, because sometimes the owner himself is a driver, or sometimes owner employs a driver and then gets the benefit also. There are I think the different types of this is not the driver alone. Probably I think that the Uber contract normally insists that the driver himself is the owner of the vehicle, because he must have some control over the vehicle itself. If I remember correctly, some of the terms that has been, sometimes they take it in as a partnership, sometimes it goes as a agreement. Only service provider that they are only providing the platform is being used. But ultimately, there is a element of oppression of the person who is said to be the beneficiary of the employment, because he has no role in the contract. Maybe as Jayashankaran has said, you are with open eyes, you are entering into a contract. It is not, you are not an illiterate person. It is a new era of business that has been come up, so that when you enter into a contract with open eyes, all educated people, you are also consulting with some people before entering into the contract. Thereafter, are you entitled to say that I am in a oppressed position? That question is always there. But as rightly pointed out by Professor Kaul and Gayathri, that when there is a possibility of exploitation of a particular person who is compelled to enter, because the change has come only because of the scenario has changed. Because you have been a period where you don't have an employment. You must seek out some employment for the purpose of your sustenance. And you don't have a bargaining power as to what is the amount of commission I must get. See, suppose in a case where I own a vehicle and I am driving the vehicle, if I am independently doing it, I will be entitled for whatever rate I will have to fix, or if some minimum rate is fixed by the government, I will have to go by that rate. Here, I think there is no control, just they are fixing the rate. And the driver has no control over that as to what is the amount of that will be, because we need only collection agent for the purpose of a platform. You call it as a platform, but in fact, the beneficiary is the person who is providing the platform service. Ultimately, he is the employer, he is dictating everything. Only thing is, he is only executing the contract that is being entered into between, rightly, in fact, that even the charges are also fixed by them. When you have the app, the charges, etc. is being coming because, as Gayathri has said, the driver has no role in fixing it. Suppose you deviate the role, again, you will have to get the permission from the platform as to whether any excess amount will have to be collected or what is the procedure to be followed, because he has no role in that. And he is only getting a particular percentage of commission. There also he has no bargaining power. This is the way in which things are going. So, as rightly said, see, it is an area where there must be some regulation. Unless there is a regulation binding both the person who is employed or who is the person said to be a beneficiary of that contract. Don't say it's employed, the beneficiary, whether he is getting the entire benefit that he expects of a employment of such nature. One. Secondly, under the Workman Compensation Act earlier, contract employees were not said to be persons employed, and there is no employer-employee relationship. But recently, the Kerala, I think that in Justice Paridipalai, in one of the cases said, it is not the nature of the employment, it is not the contract, but what is the nature of employment he is doing. If it is a permanent nature of employment as far as that person is concerned, then automatically he comes under the provisions of the Workman Compensation Act. If anything happens during the course of that employment, the person who employs them on the basis of the contract is held responsible as an owner. So that concept has come only because the contract employees are gone out of the provision at that time. But courts have intervened and interpreted the provision in such a way to bring them also within the purview of the beneficial legislation which are available for the purpose of protecting benefit. I think that is a way in which because since the matter is pending before the Supreme Court, we do not know what is the nature of decision that is likely to come. These are all the views that can be raised by the persons who are appearing before the Supreme Court for the purpose of getting or explore the possibility of the possibilities of how possibilities which will have to be taken note of for the purpose of protecting such employment. I can only say this is such employment. It is a new employment that has been thought out. And if you suppose you say that you are only providing a platform, then normally, if that be the case, you will have to say that this is my hire charge. The entire balance amount must go to the person who is getting the benefit of that the platform. That is not the case when I hear Gayathri, because entire thing is controlled by them. When there is an entire control is there on the person in the case of providing a service provider with a platform for the purpose of the what do you call, facilitating the transport service to the person who is going to employ it. One. Secondly, when you go to the app, the customer, the so-called beneficiary, that is the passenger, has no control which vehicle I will get it. It will depend upon the nearest vehicle that is also coming in the app. You can talk to them whether you will be able to come or not. Suppose I know a particular driver who is an Uber driver. I cannot have a choice of employing him. So that is there also the choice of suppose you are the owner of a cab and doing a contract service. The service, the person who is entitled to come for as an ultimate beneficiary, the passenger, has got a choice. Unless you are regulated by certain rules, when you go to the stand, you will have to go first come, first serve. Whatever be the person, he cannot deny, the driver cannot deny, I will not come to that place. He will have to go depending upon his turn. Unless such restrictions are there, it is not like that. So everything is being controlled. Ultimately, if anything happens, then any deficiency service also, the ultimate the person who provides the service, he is not liable for, but only the driver will be liable for under everything. Suppose some accident occurs, unless he have got a insurance covering the vehicle, the other man will not pay. So the entire thing will have to be met by the person. Suppose he doesn't have this thing. So these are all the areas where I think some regulations will have to come. Secondly, suppose the commission that is being paid is not sufficient for the purpose of covering the time during which he has employed or he is doing the employment. Can it be said that it is disproportionate to the time of employment that he has done? All those things will have to be taken note of, and some regulation will have to come, because unless a legislative intervention is there on these aspects, making some regulation as to how, I do not know whether the contractual employment regulation, some regulation is there for contractual employees, it appears. Whether they can be brought under that provision also, I do not know, because I am very little knowledge on labor laws. So I may not be able to say about all those things, because I remember correct that there is some provision, some enactment which deals with the contract employees, it appears. If that provision can be attributed for this purpose of bringing them also within the purview, and whatever benefit that is being provided to those under that legislation, possibly can be extended to these people also. So these are the areas where we'll have to find out. And till then, as Professor Gaul has said, the court's intervention may be required as to how this will have to be regulated. Because the legislature may take its own time as to whether it will have to be regulated or not to be regulated, whether it will have to be implemented or not to be implemented, because in some cases, acts are passed, the enforcement is not coming up. Even if I think that the 4 courts that has been enacted has not been implemented, coming to see the light so far.
They will not see the light.
And it's not seen the light, though some of the trade union people say it is good, some of them are opposing it. But whatever it be, when an act has been enacted, either it will have to be repealed or it will have to be modified according to.
You let it die its own death. You don't enforce them. That is all. Don't give the enforceability to, like it has happened in definition of industry. In the ID Act has not come into force, though it was amended in 1982. So same thing has happened everywhere. You know? Even the Trade Unions Act, which was amended in 1947, that amendment also did not come into force.
See,
that was one of the best amendments that could have been made into industrial relations.
Employees were getting the benefit of the social welfare legislation only because of the intervention of courts, by extending the definitions provided under the respective social welfare department, the legislation. Such a proactive role will have to come from the court. Still, legislation comes on these aspects.
Yes, correct.
Thank you very much.
Thank you, Ramakrishnan sir. Justice Ramkumar sir sent a message wherein when participatory ventures like this, should the state take the stand of a laissez-faire in the sense like less intervention and let the parties who are contracting, who are capable of coming into a contract, let them do the business. Is there any such specific cases that has come out? Gayathri, please, I'm just putting a question to you, wherein this has turned out to be exploitative rather than the academic discourses and what do you call the discussions wherein it might and not might become, or I would say like this is a scandal. If you open the YouTube, you find lectures after TED Talks on these things like. So, I mean, other than that, is there any specific instance like, I mean, we had child labor abolition, we had that Shivagashi or some other instances, or we had instances. Is there, because I, at my volition, after my retirement or when I job, I have free time, I just log into this, take a right, give a right to somebody, get some money, switch it off. That's me master. Isn't it really? I don't know.
See, the problem is that, I mean, I've actually gone through a couple of articles and there are a few Twitter handles. There was one Twitter handle that I had noticed of a former delivery agent. And he has uploaded a significant amount of proof to show that it's actually quite exploitative, unlike what we think. So we say that flexible working hours. But you don't realize that in order to get a bonus of 300 rupees, you have to work
negative and positive sanctions. I agree.
Exactly. So in effect, you have to work 10 hours. Only that you can, but then what is the point of working if you're not getting that bonus? Because without the bonus, it's a very, very meager amount. Even with the bonus, it's a meager amount. But the point is that there is a lot. So again, there was a case where it was actually it became a big news article where a female customer had complained that
Gayathri, one more thing you can answer. See, under the contract, how the dispute between the customer, that is the driver, and the ultimate service provider is being decided
by these platforms, and they don't take it.
No. I want to know whether any legal provision has been provided in the contract. See, normally there will be an arbitration clause or a jurisdictional civil court will be provided for the purpose of redressing your grievances. Is there any such a clause? A dispute resolution clause has been provided under the contract.
I'll put one example also. I mean,
consumer protection can
for example, in the Uber case, if a driver misbehaves or does something, and who will be held liable? Is it just the driver alone, or is that I did not pick the driver. I went to the app and I requested them, and they offered X. So as far as I am concerned, the other person has assigned him. If he does some mistake or does something, what is the legal scenario according to you?
So I don't have a blueprint of the entire contract, but in reality, what happens? This is coming back to what I was saying. There was a case where a Zomato executive was alleged to have misbehaved with one of the customers. And instead of hearing out his side, he was immediately terminated. And later on, he went to the press media, said that the female customer misbehaved with him because the delivery was late. She, I believe, pushed him or physically assaulted him, in retaliation to which he, I believe, pushed her or shoved her. So the point is that Uber or these digital platforms are immediate. If there's a complaint that is raised, it is adjudicated by these platforms themselves. In fact, funnily enough, there was an instance where the Canada Supreme Court, they noticed that this is again a gig worker issue where I think Uber employees in Canada had gone to the Supreme Court saying that their dispute resolution clause was essentially that if you have a dispute with the platform, it has to be raised via arbitration in Netherlands. So a driver in Canada is expected to bear the cost of an arbitration in the Netherlands in order to get his dispute resolved. So these are the kind of
what about the end consumer, if I may use the term? I don't know technically if I'm correct. What about the traveler, if or the person who avails the services of getting that parcel at home? If he's agreed or she is agreed, what happens? I mean,
she has to raise it before the digital platform. So you have a lot of these customer support services. She raises the complaint, and ideally they are supposed to look at both the angles. They're supposed to give
I think they have that online resolution of the conflicts mechanism that is provided in the.
And again, calls her termination of that employee does not.
No, I'm only trying to
my grievance.
No, I'm trying to tell you, Justice Nambiar, with all respect, oversimplified, because insurance can cover only some aspects. It can cover the aspects of social security. It can cover the cases of welfare measures. But what about industrial relations? Like suppose you terminate the services of employees and adopt the theory of hire and fire? What is the mechanism provided to them to get reinstatement or to get compensation from the management for their illegal termination? Or he said minimum wages. Why should from Uber we get only minimum wages? Because when we say minimum wages, we talk about those employers who are not having the capacity to pay, and they are those people who are not very small time measures, employers. But Uber has to pay. I would like to say that they should pay a living wage. Why only minimum wage? They should pay a fair wage at least. Minimum wage is something which we don't expect them to pay, because if you ask them to pay minimum wage, they'll be too happy to pay minimum wages. But I think, you have to develop a wonderful, a good, robust industrial relation mechanism to deal with the disputes that arise in this kind of employments. And that is where IT and this new gig employment, whatever you like to call it, these need a special attention by the lawmakers. But the way I look at the Industrial Relations Bill 2020, it is, to my mind, nothing but then compilation of the three legislations together and doing a lot of distortions in it. Not there is no conscious effort gone into making, streamlining it into a legislation which is said to be having a rationality. I don't see any rationality. You'd make a distinction between, remove the distinction between public utility services and non-public utility services, which is so well conceived concept in our services to the society at large. You put restrictions on right to strike and make all strikes illegal. And you say that we are providing for collective bargaining. There is only one provision, and the yardstick that they have put, the minimum standard, they will never be a recognized trade union. There's no mention about how recognition is to be got. What are the rights of the recognized trade unions? Now, these are all, you do an exercise which is an exercise in futility. In today's world, you have to make a law which is robust, rational, and it is what answers the felt necessities of the time. And if you create more problems, it is better to allow the old law to continue rather than give a law which is having no head, no tail, no neck. So therefore, what are you trying to do? You're trying to tell us that we are giving you a new code. What is this code all about? I don't think government is clear about it. Lawmakers are clear about it. There is no thinking which has gone into it. And I don't think it answers the questions of the new problems which have been posed by the IT. You have 4 codes, but then they have no responses to the present day world problems. That is my.
So not only so, I want to know one thing more, whether this type of business contract, if you call it as a business contract, is there any registration required for the Google platform or the platform service provider with India for that purpose?
I do not know whether there's a
because unless such as some regulation is there regarding having a business contract with a person having a hold in India, person controlled from outside, unless there is something is there, how can it be regulated? I think
by there must be some, which I think Gayathri is better informed on that. I am not that informed about that.
No,
but
because I am also
I know that
about it.
There is a lot of things that need to be seen in the present, legal system itself, to see in certain cases that we can build up that for the time being, courts can
for
evolve.
example, a foreigner want to make investment. The RBI regulations are there, FERA regulations are there, some registrations, etc. required. Whether such type of any restrictions or regulations are there for having such a type of business contracts?
I'm sure there must be, certainly, yes.
And probably Srikanth may be able to enlighten on these things.
Yeah.
Yes.
Can I, so the crux of the, Gayathri, can I make my comments, sir? Shyam sir?
Why not? Please.
Gayathri, thank you so much for the presentation. Uber must have wronged you in many ways to have spoken at so much length about the exploitative practices. There is a commonality between me and you. We are situated, I believe, in the same geographical area, which is Bangalore. And we are talking about a case which is the UK, where I practice. Now, that being said, if you look at the Uber BV Aslam case, which was delivered in November 2000 or June 2021, reported in November 2021. It was, let me first answer Justice Ramakrishnan's question, which was whether there are local entities which will, on the basis of which certain decision is made, whether a particular statute has to be applied. And in that particular case, Uber had a local entity which was basically administering the platform. So that was a fundamental reason on which that particular judgment was delivered. Now, insofar as
Now, what was the dictum in that decision? Favorable to the Uber or not?
That Uber had a presence in the London area, and such presence in the London area made it a company. Insofar as whether it is a domestic company was not answered. The question insofar as whether it operated in the London area was answered in affirmative, and the decision that was rendered was that certain legislations will apply. Now, I would assume that India would have something similar. Now, that being said, I believe I would start my comments in terms of there are protections that are, again, I'll answer Justice Ramakrishnan's question with regard to the bi-party contract that are entered into. One is a contract which is, or the implied contract that you enter into, you as a user enters into with the app. And then there is a contract that the app enters into with the driver. Now, insofar as the exploitative practices, or if that particular contract has a circumstance which will put the other party of the contract at a diminished position, I believe the Indian Contract Act, along with any other acts, even if we talk about a welfare legislation, the Contract Act is not a welfare legislation. Let's be very clear on that. The Contract Act merely says that this is a contract and this is not a contract. And then addressing Justice Nambiar's point, which was legally valid contract, which satisfies the basic premise of offer and acceptance. And if it satisfies the nature that you were not forced into that, which is duress that we talk about. There was no duress for you to enter into that particular contract, which basically means that an Uber driver has to choose Uber and has no other alternative to choose from, which will result in the exploitative practice. I believe we have failed that particular condition to bring a claim under the Contract Act and damages and reparations and so on and so forth. Now, if I may draw an example or an analogy in this particular nature, is when you talk about BITs, which are bilateral investment treaties, or when you talk about foreign investments. Let's say I want to invest in Malaysia, and Malaysian government signs a particular contract with me, which says that you will not be charged 15% tax, you will be charged 7.5% tax. Now, whether this is and Malaysian government, after signing that particular contract, says that no, we cannot do that, and we will have to charge you 15% tax. Now, that was a contractual, I would say, reneging, which happened, which will bring a claim. And then the exploitative practices and so on and so forth continues. Insofar as the aggregator rules is concerned, and again answering Justice Ramakrishnan's question, I have sent to you the MORTH, which is the Ministry of Road and Transport, which is notified that a minimum fee has to be paid insofar as the aggregator rules is concerned. This is guidelines, this is not a notification, this is not an act, and so on and so forth. So they have taken cognizance of this particular fact. They have taken cognizance of the fact that this exists. As a matter of fact, even now in Karnataka, aggregator rules are being framed, and they are being in the process of being implemented, and so on and so forth. Now, the question insofar as whether it is exploitative, whether there can be a class action suit that can be brought, and whether such class action suit can give enough reparations or damages to everyone who has consented to that particular contract, I unfortunately have to disagree and say that it does not lie in the Contract Act. It lies only in welfare legislations which are outside the Contract Act and at the discretion of the courts as such. And I believe if I were to be arguing on Uber's side, I would purely take this as a contractual claim and say that this particular contract, which was entered into in free will and without duress, and if no duress is being or mitigating circumstances are being proven, the contract is absolutely valid.
No, not that,
We do the same.
One more thing I can answer. Suppose even if it is a valid contract in the eye of law, because you open eyes, you are doing it. If it is a terms are unconscionable and oppressive in nature, will it not be possible to say that the contract has vitiated on that account, and then the general legislation general welfare legislation will not be employed for that purpose?
Unless the contract is violative of any principles or the law as such, I do not.
Because even if it is a terms are unconscionable, where I don't have a role at all, it is a one-sided.
There is absolutely no law in our country which says that I cannot enter into a losing or what you call which does not generate profit, or I tend to lose, because it's your business acumen and sense that compels or makes you enter it, unless and until it can be seen that as a class they are being exploited. An individual can be foolish to enter into a foolish agreement. The court will not step in to save him, saying that it's unconscionable to make him suffer the loss. He has done something foolish, he'll have to suffer the consequences. But unless and until a category or a class or a distinguishable group is shown to be suffering on account of these things, I don't think anything or anybody can step in.
I believe the remedy lies in Section 3 of the Competition Act, where the Competition Commission can step in and possibly monitor this particular activity which is being done by these particular aggregators. I believe we are singling a particular aggregator out. There are many aggregators out there who are performing similar things. And gig economy is not new to India. We have been having gig economies from the time that we have had maritime trade. And even now, dock workers have their, which are typically gig workers who work in the dock. They work, they don't clock in and clock out, and they have their own working styles and so on and so forth. So I believe, I believe that a welfare legislation which is focused on the Ubers and the Olas itself will be subject to a claim by Uber or Ola, which will say that they have been discriminatorily acted upon by that particular legislation. So what will we do to that particular legislation if at all it is being passed?
We are just
illustrating it.
See, Uber and Ola were taken as a illustrative purpose.
No, it is not illustration, sir. It is not illustration.
See, suppose you are food suppliers, you are the provision suppliers. Everybody will come in this.
No, sir. It is not. It is not. I would vehemently argue against it, because if you look at the guidelines which is issued by MORTH, which is the Ministry of Road, it has specifically issued guidelines for regulating taxi fares and nothing else.
No, that's and if it has to do with roads. It cannot do with
the roads.
Yes. But a consequent legislation or a consequent guideline should have been issued by the Ministry of Consumer Affairs as well.
No,
that of course,
probably,
that of course.
probably that has happened only because the Uber and Ola supposed to be more economic and less expensive when compared to the fixed fees. So probably the dispute arose between the one type of employment and other type of employment. Thereby, the others are losing it. So
Correct.
probably that
So-
may be the reason
so
why
that
they
was
have done it.
Inequitable bar. Now let's take another example, which may be of interest to Gayathri. We are all signing into, for example, even this particular Zoom meeting. We said that the meeting is being recorded. We said got it, and we are entered into the meeting. Now this is one-sided. Now, if it's one-sided, can I go to the court that it is exploitative? I'm sorry, Shyam sir. I'm taking a very.
I'm even otherwise exploiting all the resources and the knowledge that you are having. We are
For
sharing
good
it.
cause, you can always exploit things. Yeah.
No, exploitative is a very, very vague term, and exploitative is very, very circumstantial, and it is based on the particular action which has taken place by that particular exploitation. And if there is an injury that is caused because of that particular exploitation, then the cause of action arises. In the UK, there is absolutely no provision of a class action. In the United States, we have a class action which could be actioned upon. In India, we have the trade unions which typically make these claims as a PIL or writ petitions and so on and so forth. So the point I'm trying to make over here is. There are different, if the court starts to step in for exploitative analysis of every contract which is out there, the Supreme Court is on a backlog of about 89,339 cases. The last I checked, we are going to be surrounded with constitutional questions which will have wide legal ramifications, which I feel is not in the interest of justice at the moment, at least.
Correct.
So
I
if
mean-
I may respond to that.
Sure.
So the difference is each contract is not tied to a statute. What has happened, this is precisely what the UK Supreme Court said. They said it's not a contractual issue. We are not looking into the validity of the contract. We are just seeing how much importance do we give this contract when we look at the more overall holistic picture of whether these workers fall under these statutes. That is the question. So unfair contracts exist, no doubt, but do you have a statutory right? Does that contract negate a statutory right? Here what has happened is the workers are saying that please don't go just by the terms of the contract. They're not saying that the contract, they're not going to the civil court saying that we are trying to enforce the contract or we are trying to vitiate the contract. They've gone to the Supreme Court saying that we have certain rights as per statutes. Please give us those rights. And in UK, what the court has said that contract, when you want to look at the real relationship, look at the overall conduct. Contract forms part of that conduct, but it's only a limited part. Look at the other aspects. Don't just go by what the contract says. So the question is more so about the statutory interpretation versus a contractual interpretation. It's
Understood.
not about.
But again, sir, rebuttal to your point is that at the max will give me a inclusion in insurance or any other welfare legislation at the very maximum.
Correct.
Now, any other reparations that I'm seeking, apart from inclusion in a welfare legislation, where will I go?
That is, of course, so in the suit, I mean, the petition that lies today before the Supreme Court, they're not asking for any reparations again, other than what has been prescribed under these enactments. They're only asking for certain welfare schemes to be created in their name, in the same way it's being created for other unorganized workers, saying that we are also unorganized workers as per
Then again, the
statutory
term worker, is it a misnomer or not? We'll just the comments before we go to KVJ Rao sir for the concluding remarks. We just get the comments from Professor Dr. Rose Verghese. Please, ma'am. You'll have to unmute. Yeah.
No, sir. From the thrice I spoke in your forum where you saw I confine myself to criminal law and criminology and penology. So, I'm a criminal. It's being recorded, sorry. And
So we have got two
I
criminals
will
in the
venture,
platform.
but then I
Just
take
like
the
just like
opportunity.
Ramkumar says, conferred criminal.
I too am. But I take this opportunity. I'm sorry, I'm not going with the topic, sir. But I take this opportunity to really appreciate Advocate Shyam Padman for this initiative, because each time he's coming out with a topic. See, I sat down today because I was going to hear this for the first time. So for that, I'm really, really appreciating Advocate Gayathri Poti. When Chief Justice Gopalan Nambiar was a Kerala High Court, the Chief Justice, I used to appear several times. If I'm not mistaken, it's court number 8, where Justice Subramanian Poti and Justice Khalid sat in a division bench listening to admissions. So I was very happy to be here today. And of course, it's a growing topic with experts like my friend, Professor Dr. B.T. Cole, who is here.
Oh my God. How are you, Ras?
Fine. So, so nice to see you all. And also Dr. Srikant Pathasarthi, I was really amazed at also his level of knowledge. I really appreciate all of it. But I must tell you, with experts here, I wouldn't venture to talk on the subject. But I want Gayathri Poti to know that when I went to do my LLM, Justice Subramanian Poti told me, you're doing very well in practice. Of course, he knew I was only 5 feet tall and he wanted me to put on some height. So he told me that. And he said, you're doing well. You should not give up practice. And not that you should not take an LLM. But if you go for LLM, you're going to go into academics. But I told him, no, Your Lordship, I want to come back to practice. But I wish I could share with him today that I went for not only LLM, then I went for MPhil and PhD at Delhi University. And then after being the dean in Delhi University, I came as vice chancellor of the National Law School, Kochi. I wish I could share this with Justice Subramanian Poti today.
You should join profession again.
I wouldn't mind if somebody wouldn't. Really,
I would be very proud of you, ma'am.
I must tell you why I went into teaching, because I enjoyed Professor Cole will agree with me. I had a passion for teaching, and I teach criminal law, criminology.
So her husband also, Rose's husband also is a very fantastic teacher. He's a friend of mine, taught with me. We're together in the same place, we taught together. Yeah.
No wonder this is a family get to the platform.
Yeah, so I apologize for not talking about the subject.
No, absolutely not. Because
already happened. But
this is the way we exchange ideas. This is the way we inspire each other, and this is the way in which the platform goes along. And thank you, ma'am, for that, and for the concluding remarks.
I would take this opportunity, sir. But I would take this opportunity to ask Dr. Srikant Pathasarthi and Advocate Gayathri Poti to visit Ramaya College of Law, where I'm Director Academics, and share this with my students. Because I'm learning from you today, and I'm sure my students would be benefited by this. For that, I'm thankful to Advocate Shyam Padman. Sorry for deviating from the subject.
Absolutely. It's a pleasure having you on this platform. Over to you, K. Rao, sir, for the concluding remarks.
Good evening. Gayathri, good presentation. When I saw the topic, I was wondering what it was myself. And now that I hear, it's a topic after my heart. And I'll tell you why. I come from a family, father and son, 60 years in the aviation industry and 30 years in the industrial field, industrial relations. My father was industrial relations manager with Air India for 18 years. Father and son were on the opposite side of the table. I as a union leader and he as a management. And that table came even to the dining table, and we used to have fights, heated arguments on the dining table. Plates flew, glasses flew, till one day my mother said, you don't have dinner together, or if you're having, keep your mouth shut or stuff your mouth. Having said that, let's come back to the topic. Whatever I say now is like holding a candle to Khalsa. Exploitative contracts have always been a phenomenon. You can take any employer, show me an employer who will not enter into an exploitative contract. You spoke of pilots. It was only the Allahabad High Court in 77 that said they were workmen, even though at that point of time they were drawing a salary of 80,000. Where the court said salary was not the
Criteria.
point of reference, but what is a job function. And then it went on. In 85, we had the workmen of the Food Corporation, where contract labor was being brought in through the back door. Sir will bear with me. In fact, the Supreme Court, the Constitution bench at the Supreme Court had to go one step and say that if you do this, it's a criminal offense. It had to put it in that many words. So you see, having contracts, even today, like, I mean, I can talk of many things, companies, but I will restrict myself to the aviation field. Today, most of our employment in the aviation field are exploitative. And we all are educated. Some of us are graduates and some of us are postgraduates. But at the end of the day, when it comes to between stomach and the brain, the stomach will always take over. And so that's exactly what came out of your presentation today. At the end of the day, I'm looking for employment, whether it is part-time, whether it is full-time, because I need to make that money to either to make two ends meet or to provide for the family. So every contract is always going to be against an employee, because the employer is here to make profit. He's not here to give you the benefits of all the acts. And as Justice K.T. Thomas said in the recent valedictory, he said most of the lawyers are going into corporates, and those are the people who draft these contracts. So, so ultimately, it's a circle. It's a vicious circle which none of us can avoid. Yes, like you put in today, the gig workers, what they are seeking may be a fundamental right, in the sense that a right to a good life, which may not be included in their contract. So they want those terms to be amended in such a manner that they get at least minimum, like as Sir said, why should it be only minimum wages and not regular wages? Since the platforms are very huge, billions of dollars are involved. So there is, I mean, everybody would like to fight. Yes, trade unionism is no more what it used to be earlier. I agree with Shyam sir. And his state was at the pinnacle of trade unionism at one point of time, and fought for the workers' right. But later on, when politics came in, and like Sir said, legislation really doesn't help, because today the legislatures who legislate, honestly, tell me how many of them even know what they're legislating. It's a paper put up by the secretaries or put up by a team of secretaries. They just come into Parliament, they read it, they say yes, this is what we have done. And we all know that there is lobbying going on in the Parliament, as we say, in the streets of Parliament. There is lobbying going on.
Corridors of the Parliament.
Corridors, yeah.
Corridors of power.
The corridors are too little today, sir. Now it has become so wide; it's become a street now. So that's exactly what I was coming to. So ultimately, legislation, as Sir said, there are so many legislation. Now all the labor laws have been mixed into three parts. We're fighting that. But unfortunately, the trade unionists have not gotten together like the farmers did for these three things. So ultimately, every contract, I'm sorry, Sir, I'm just...
just like Sir said, it's not just the old wine in new bottle, but the old wine has been adulterated as well.
Yes.
Yeah. Yes.
And dirty bottle.
Sir, see, let me tell you, sir, wherever a politician comes in, the issues will start. So and this is what I have seen very, very clearly, sir. Like I entered unionism in 1997. I mean, I was leading a ladies' union at that point of time. I was the general secretary of the Air India Air Hostesses Association, where we were fighting discrimination which Air India had between men and women for. Nargis Mirza case.
Nargis Mirza's case, yeah.
Yes, Nargis Mirza case. Yashaswini Merchant, we got it overturned, and ultimately the Supreme Court overturned that. We won it in the High Court, and we lost it in the Supreme Court. So ultimately, what happens is every contract has to be looked threadbare into a lot of issues. And the rights, I wouldn't say rights, but whatever little is required by legislation needs to be taken care of. And it is really a tough battle, and I'm honestly telling you, like last the earlier one, we ended with that, Shyam sir, and we ended with that what if the legislation doesn't come in, what do we do? I said, we still continue fighting it in courts. You don't have a choice. You don't, it's a Hobson's choice. Like the contract that you're talking between Uber and the driver is a Hobson's choice. But how do we bring in our fundamental rights and get it into at least some semblance of humanity in it? A human element is what we are looking at it in any contract. So having said that, excellent articulation, well
Not only that,
presented.
see, till Migrant Laborers Protection Act came, nobody was thinking about the plight of the migrant laborers.
True,
Yes.
sir.
Thereafter, some registration, regulations, protection, etc. came. So that way, something will have to come.
Even after that legislation came, it was only in Salal workers project case. Justice Bhagwati put life and blood into that legislation and brought, accountability. Otherwise, people had no knowledge about that legislation having come in.
Also, during the COVID times, when the migrant labor wanted to go back, how many people helped them?
Yes.
They were left on the streets. They were
Not even
left on the
Supreme Court.
streets.
Not even Supreme Court.
Yeah, exactly. Supreme Court said this is not our domain.
No, originally, but subsequently they so moto again taking it up and then.
But again, I don't see much soccer coming from that judgment either.
No, I understand. Also, like I said, I only hold a candle to you. I mean, I'm very small in front of you. What little that I know is what I just spoke. And as Parthasarathy sir said, agreed that, the transport people, aggregators may be governed by the Ministry of Transport, but the rest of the people have to be governed by somebody.
Correct.
They like, there is if there is foreign direct investment, those rules are also there. So we need to exploit and see how we can fit in all that into the framework to get a good, I wouldn't say a contract, but a legislation. Okay, this is what they will get if you sign this kind of a contract. I do agree with you. We signed the contract with open eyes. And you mean to say they're not changing? Even today, I'm in the Supreme Court, where Air India has changed our service conditions unilaterally without Section 9A notice. And we had the Attorney General try to defend it, and Justice Lodha told him, what are you even saying? That you're not governed by 9A. How can you even make that statement? And as recently as 2019, in Paradeep Phosphates, the Supreme Court itself had Section 9A was mandatory, even to take away a benefit that was given after 58 years. Said you increase the age from 58 to 62. Now you want to bring it back to 58, you still need to give them a notice. It was not a bonus. It was not a largesse. So there are laws, there are a lot of issues that needs to be taken care of in such kind of contracts. So with that, I'd like to end, and I thank you very much, Gayathri. Nice sharing the platform with you, and thanks everybody.
Sir, I would say that the topic, the presentation, the way in which the speaker, the introduction, all which speaks, it can be seen 5:30, now it is 7:50, and still the debate continues. So this is something that is to be deliberated and debated. But I think without the risk of contradiction, I may be able to sum up by saying that the quintessence of today's discussion is that, can a welfare state turn a Nelson eye on the practical realities of the new technologically driven economies, maybe gig economy or some other terminology you may say? Should there not be ways and means of addressing the concerns of all stakeholders? Let us not think it's a victim-oriented or something is exploited. No, we want these things to explode, that the economy will become vibrant. So for that to happen, all the stakeholders will have to be taken into confidence, and there should be ways and means of what do you call that, harmonious existence. How can that be brought about should be the concern of everybody. I'm sure that Gayathri is doing research on that, and with all these academicians and judges and others, I'm sure that something will come out of this in the near future, and Supreme Court will be addressing this issue. I hope that this may not be seen as if that the wolf and lamb story or something like that. No, here just like Justice Jayashankaran Nambiar sir said, that it's not the workmen of the old era. They are now having their own ways, and I just believe that more suicides are now happening from the side of the management, not from the side of the workmen, because they are unable to run the show and they are running into debts because of different reasons. So with this, I'd like to thank Justice Giri, the Senior Advocate of Supreme Court, for introducing this wonderful speaker to this platform. In absentia, I thank him. And this is Jayashankaran Nambiar for the wonderful introduction. Gayathri, of course, for making this Saturday evening so wonderful with a new subject, new thinking pattern, and new way that we were able to approach an issue. Justice Kaul, sir, it's wonderful to have you back, and we won't leave you. You better stay back or we'll come out to Delhi. That's another story.
Most welcome, most welcome, most welcome.
Raman, sir, I know that you say most welcome because just like the seer said, Delhi bahut dur hai. So
Kerala bahut dur hai.
Thank you, Justice Raman, sir. Thank you, Rose Madam, and thank you, Shrikant, Rao, sir, and all of you wonderful participants for making this 267 session such a wonderful one. We look forward to see you more often on the platform, Gayathri, so that we can exchange ideas and be a part and parcel of this, because whatever topics, your inputs also will be valuable, because we'd like to have everybody come in, pull in their resources, their thoughts, so that we'll all go back, if nothing has happened, empowered and enriched. Thank you very much for a wonderful evening.
Goodbye.